In addition to taking your case all the way to court, there are alternative forms of dispute resolution, and you may be required to go to one of these forms of alternative dispute resolution, either by a court order, if your case is a relatively simple case like a personal injury case, where the outcome is fairly predictable, even the amount of the damages is fairly predictable. The judge may say, before you have the right to take this thing all the way to trial, I'm going to require you to go to a court-ordered mediation or arbitration to see if the case can be resolved by a mediator or arbitrator. And then if you still don't have the thing resolved, then we'll let you have a trial. You may also be required, however, to go to some form of alternative dispute resolution by virtue of the terms of the contract that you have signed in some kind of business transaction. More and more often, especially big corporations, but businesses in general, are recognizing that the court system is not the most efficient way for them to resolve disputes. It takes way too long, it costs way too much money, it's too unpredictable. And so they put clauses right in the contract that says if you get in a legal dispute with them over this contract, and you're agreeing ahead of time by signing the contract, you cannot sue them in court. Instead, you have to go to an arbitration or a mediation and resolve your dispute there. There are also the three most common forms of alternative dispute resolution are negotiation and settlement, mediation, and arbitration. There are also exotic forms, and they do come up, but they're fairly rare. One example of a more exotic form of alternative dispute resolution, if there's a major lawsuit going on between two giant corporations and there's millions of dollars at stake, before they go to trial, by agreement, they'll go out and hire a retired judge or a fake judge and a fake jury, and they'll try the whole case in a mock trial, a fake trial, before the regular trial, just to see what a jury of average citizens, see which way they decide the case. And then if they award millions of dollars in favor of one corporation and against the other, those corporations may decide to make a business decision and not take this all the way to trial and roll the dice. They may settle. But those forms of alternative dispute resolution are rare, and we're just going to look in this course at the three most common forms: mediation, arbitration, and negotiation and settlement. All we need to say about negotiation and settlement is that you can settle a case at any time, at any phase of the proceedings, as long as the parties agree. So you can settle a case before the lawsuit's filed. You can settle a case after the lawsuit's filed, but before it goes to trial. You can stop the case in the trial and settle in the middle of the trial. You can settle the case after the trial is over and a verdict has been entered, but you're quibbling over whether or not you're going to appeal. You can settle a case at any time the parties agree to a settlement. So let's move on then and look at arbitration and mediation. The things that you need to know for an exam in this course is the difference between an arbitration and a mediation, and then with regard to arbitration, the difference between binding arbitration and non-binding arbitration. So the difference between mediation and arbitration is that in an arbitration, we appoint someone to have the powers of a judge, and they actually have the power to decide the case. So we pick an experienced lawyer or somebody else, a retired judge, and that person has the power of a judge. We come in and we present our case to them, less formally than in a formal trial, but we present our case, the opposing party presents their case, and the arbitrator just actually decides the case. Judgment in favor of George for $100,000. Now, what happens when the arbitrator enters that decision depends upon whether or not the parties agreed or the court ordered that this was binding arbitration or non-binding arbitration. If it was non-binding arbitration and the losing party doesn't like the arbitrator's decision, he can say, I reject the arbitrator's award and I want my day in court. And the case goes on to court and it gets decided in court. Now, if that guy who rejected the arbitrator's award doesn't get a better result in the court, then he's got a problem, because he may be required to pay all the other side's legal fees from the time of the arbitration forward, and that might be thousands of dollars. But if you lost the case and you want to roll the dice, that's your only option. If, however, the parties agreed, the contract says, or the court ordered for some reason, that it was binding arbitration, then once that arbitrator's decision is made, that is the final decision of the case. You can take that arbitrator's award over to the courthouse, have it made into a judgment, a court judgment, and you can proceed with judgment collection procedures the same as if it was a court-entered judgment. So binding arbitration, no appeal from the arbitrator's decision. Non-binding arbitration, the losing party has the right to reject the arbitrator's award and go on and have his day in court. What's the difference between arbitration and mediation? Okay, in an arbitration, the arbitrator is given the power to actually decide the case. But in a mediation, we appoint a third party as a mediator, and that person does not have any power to decide the case. Their only job is to act as a neutral third party and to hear the arguments and the evidence on both sides of the case, and to attempt to help the parties to negotiate some form of compromise and settlement. So mediator does not have power to decide the case, just helps them mediate a decision, a compromise. An arbitrator is given the power to settle the case, or to decide the case. So that's the difference between an arbitration and a mediation. Now, before we leave the subject of mediation, you need to hear a few words from me about the history and the public's opinion of mediation. The worst place that you can go into the American court system is the divorce and family law court. And it's very unfortunate, because for most middle-class Americans, during your entire lifetime, your only personal experience with the American court system is your divorce. And you go into the divorce court, and it works terribly. And there are some unethical things that happen with the divorce lawyers, but it really works terribly because of you. Because you almost always go into the divorce lawyer's office and at the beginning, and you say, all I really want is for us to depart as friends, and for us to have a fair settlement of the property issues and the child custody and child support and spousal support issues. That's what you say, and sometimes that's what you mean at the beginning. But by the time the case is over, what most of you really want is blood and fire and revenge. And the court's not set up to get you blood and fire and revenge. The court's only set up to try to get you a fair resolution of the property issues and the child custody and support issues and the spousal support issues. And so whatever you get out of the court, you're usually feeling unfairly treated, and you go away from your experience with the court system is negative. A part of that negative experience is often a court-ordered mediation. If you have a dispute over child custody, you may be ordered to go to mediation, and one of the mediator's jobs is to see what is in the best interest of the children, regardless of what the two of you disputing parents want. And so at least one of the parents who was there wanting blood and fire and revenge and trying to use the children as a weapon against the other parent, which is a horrible thing to do. Shame on you. But you don't get to use your children to punish the other spouse, and so you come away from the court-ordered mediation with a bad experience of mediation and bad-mouthing mediation. And it is unfortunate that for most people in the American middle class, their only exposure to mediation is in the family law system, because outside of the family law system, mediation can be a wonderful tool for resolving disputes. Let me just give you one example. Years ago, I had a court case going on between a homeowner and a contractor. The homeowner had hired the contractor to do a major remodeling of his house, and the remodeling didn't come out exactly the way the homeowner wanted it, and he was refusing to pay. and suing for damages to his house, and the contractor was suing for his money that he didn't get paid. And these two people had been going at each other for a year or two, going up through the court process, and they were almost all the way to trial. And the court ordered them to go to a mediation before having their day in court. So he took these guys into a conference room at a mediator's office. There was an attorney downtown Sacramento, a woman attorney who was an experienced construction law attorney. And we take them into this room, and they are so filled with hate for each other and anger. Anger comes out of fear, you know. But they were so angry at each other that the two lawyers had to grab them and physically hold them back from diving across the conference room table to try to punch each other out. That's how the mediation began. But we had a highly skilled, trained mediator. This woman came in. She worked with those two disputing parties for 3 or 4 hours, and they settled the whole case that they had been fighting in court for almost 2 years. Not only did they settle the whole case, but when the mediation was over, they walked down the hall together, shaking hands and talking to each other like a couple of friends. That's a freaking miracle. And you don't see that happen in the courtroom very often. That's the kind of miracle that a good, skilled, trained mediator can accomplish if you give mediation a chance. So if you're ever involved in a serious legal dispute and someone asks you if you'd consider trying a mediation, give it a try.